And a very warm welcome to this, the fourth in the series of 9 Gough Chambers webinars. I hope everyone's well and coping in these difficult times. Thank you to everyone for attending, and thanks to those of you who've been at our previous events and for coming today and for sending us some feedback. I'm delighted this morning to be broadcasting this webinar from the conference room at our main conference room at our new Norwich Street premises, and we're all very much looking forward to welcoming you all here in person very soon. As usual, if you have any questions for our speakers or for myself, please put them in the chat box. Alternatively, you can contact us or the clerking team through Chambers in the usual way. We have 2 of our leading junior members of the PI team presenting this morning. In a few minutes, you'll hear from Tibbitts, who's providing an update on fatal accidents claims. But to start with, I'm very pleased to introduce Esther Pounder, who will be talking today about the Supreme Court decisions on vicarious liability, dealing with the most recent cases of Morrisons and the Barclays Bank cases. Many thanks to everybody. I hope you enjoy this morning. Esther, over to you.
Hello, good morning everybody. Thank you very much for joining us this morning. I'm going to be looking at 2 recent cases, both of which came before the Supreme Court in November of last year and in which judgment was given in April this year. I've got a slightly glitchy problem with my slides, so Mona is going to be in charge of my slides. So I'm going to be asking her to flick through the slides as and when we need to move on. So Mona, if you move on to the next slide for me, please. So the 2 cases I'm going to be looking at, as Adam indicated, are the Barclays Bank case and the Morrisons supermarket case. Next slide, please, Mona. Both cases had the same panel in the Supreme Court and lead judgment given by Lady Hale. Before we start looking at the 2 cases, it's probably worth reminding ourselves briefly the 2 elements of vicarious liability. Firstly, there must be a relationship between the 2 people, which makes it proper to make one pay for the fault of the other. And secondly, there must be a sufficient connection between that relationship and the wrongdoing of the person who committed the tort. Lady Hale observed in the Barclays case historically, and leaving aside relationships such as agency and partnership, when you're looking at the first issue, that's historically been related only to the relationship between employer and employee. The second element is going to be looked at in the Morrisons case. Mona, could you move on to the next slide? Next slide, please, Mona. Lovely. So let's look at Barclays Bank. Just one second. So Barclays had hired a doctor, we call him GB. He was asked to perform medical examinations on their new employees, and mainly these were young women leaving school, about to start work at the bank. The bank arranged the appointments with GB. He told the applicants when and where they had to go, and they provided him with a pro forma report to be filled in, and he was paid a fee for each report. Examinations took place between 1968 and 1984, and many years later it was discovered that he had allegedly sexually assaulted 126 patients during the course of those examinations, and those individuals brought proceedings against Barclays. Barclays defended the claim, saying, well, they had no contract of employment with GB, and so they couldn't be vicariously liable for his actions, and he was an independent contractor. It's probably worth stopping to look at what sort of practice GB had. We had what his son described as a portfolio practice, so only some of the work he undertook was for Barclays. Some of his work was medical examinations for other organisations. He did reports for immigration purposes. He also did work for insurance companies, a mining company and a government board, and he also wrote a column for a newspaper. Next slide, please, Mona. So case went to the High Court, first of all, and there it was held the bank was vicariously liable for any assaults. Looked at the 2-stage test we've already talked about. Both limbs were satisfied and Barclays were vicariously liable. Next slide, please. Off to the Court of Appeal, Barclays appealed and their appeal was dismissed. And what the Court of Appeal said was that the degree of control held by Barclays over the examinations was perhaps the most crucial factor. Examining the health of their prospective employees as a pre-employment check was an integral part of their business and interests. So off we go to the Supreme Court. Next slide, please. And Bank's position was, although there have been some recent decisions which expanded the categories of relationship which can give rise to vicarious liability beyond simply contract of employment, it wasn't extended to the extent that you remove the restriction in relation to independent contractors. Claimants said, no, that's wrong. If you look at the recent Supreme Court cases on the issue, so the Christian Brothers case, Cox and the MOJ and Arms, that trite proposition, no liability for independent contractors, has been replaced with a more, what they described as a nuanced multifactorial approach. A range of incidents can be considered, and you look at that to decide whether it's fair, just and reasonable to impose vicarious liability. So quite an extended definition, they said. Next slide, please. Lady Hale looked through the line of cases on vicarious liability, with particular focus on the Christian Brothers case and Lord Phillips and his analysis at paragraph 35 of his judgment, in which he sets out a number of policy reasons, which he says make it fair, just and reasonable to impose vicarious liability on an employer. And those are, next slide, please. Next slide, please, Mona. Thank you. The employer is more likely to have the means to compensate the victim, and there's likelihood is that they'll have insurance. The tort will have been committed as a result of the activity being taken by the employee on behalf of the employer. Number 3, the employer's activity is likely to be part of the business activity of the employer, which the Court of Appeal had focused on. And the employer, by employing the employee to carry on the activity, had created the risk. And number 5, the employee will, to a greater or lesser degree, have been under the control of the employer. So those are Lord Phillips' five criteria. Next slide, please. So it's worth facts of the Christian Brothers case, just while we're touching on it. In that case, the claimants were students at a residential school owned by the Catholic Child Welfare Society. They also employed the teachers. Some of the teachers were members of the Institute of Christian Brothers. Serious sexual and physical abuse was alleged against some of the brothers. And so the issue in that case was whether the Institute could be vicariously liable jointly with the Catholic Child Welfare Society. And what Lady Hale said when she looked at the Christian Brothers case was there seems to have been a tendency to elide the policy reasons for the doctrine of the employer's liability for the acts of the employee, as set out in paragraph 35, i.e. the 5 policy reasons that we've talked about, with the principles that should guide the development of that liability into relationships which are not employment, but which are sufficiently akin to employment to make it fair, just and reasonable. So she's saying that there's been a pushing together of those 2 issues by the Court of Appeal, and that's not the correct approach. So she says, having reviewed the Christian Brothers case together with Cox and Arms, she says the question therefore is, as it's always been, whether the tortfeasor is carrying on business on his own account or whether he's in a relationship akin to employment. So although she also says, although they're enunciated in the context of non-commercial enterprises, it might be relevant in deciding whether workers might be technically self-employed or agency workers to look at whether they're effectively part and parcel of the employer's business. But the key will usually lie, she says, in understanding the details of the relationship. So where it's clear the employee is carrying on the tortfeasor carrying on their own independent business, it's not necessary to go on and look at those 5 incidents. So next slide, please, Mona. So in this case, when you apply those cases, Lady Hale says GB clearly wasn't at any time an employee of the bank, nor when you look at it objectively was he anything close to an employee. He had his own portfolio of clients and work as a doctor. he wasn't subject to a retainer, he was free to refuse work from Barclays, and he was expected to have his own medical liability insurance. And so in those circumstances, it was clear to the Supreme Court that he was an independent contractor. And Lady Hale made reference to a range of other people who did work for the bank, but clearly independent contractors, from the window cleaners through to the auditors hired to audit their books. And she said he was in business on his own account as a medical practitioner with a portfolio of patients and clients. One of those clients was the bank. She did go on and look at whether the concept of worker that's changing in other contexts had anything could lend any assistance here. And she said the fact that the concept of worker is changing in the employment law context, talking about the gig economy and so forth, she said that there's obviously changes going on there, but she says it would be going too far down the road to tidiness for this court to align the common law concept of vicarious liability developed for one set of reasons with the statutory concept of worker developed for quite a different set of reasons. So she accepts that difference exists, but you don't need to tidy it up in this way. So she closed down that particular avenue. So what's the takeaway from the Barclays case? Well, in essence, when you're considering if an individual or an organisation might be vicariously liable for the actions of another, you still need to ask yourself that key question. Is the person who committed the tort carrying on business on their own account, or are they in a relationship akin to employment? In uncertain cases, Lady Hale makes it clear, you can go on and look at Lord Phillips's 5 issues, but I think it would be reasonable to be quite cautious about the prospects of establishing vicarious liability in any case where you need to go that far. What about an argument the defendant was under a non-delegable duty of care? Well, that's something the Supreme Court mentioned in passing, and I suspect that's going to be the next battleground now that the requirements of vicarious liability have been clarified or tightened up, depending on your view, by the Barclays case. Next slide, please, Mona. Okay, let's look at Morrisons. In this case, the Supreme Court looked at the second element of the vicarious liability test. So is there a sufficient connection between the relationship between the parties and the wrongdoing of the person who committed the tort? So what were the facts? Well, Mr. Skelton was an employee with a grudge. He'd had a disciplinary matter with his employers, Morrisons, a little while before this, the facts that gave rise to this case, and he held a significant grudge against them. He was a senior auditor employed by them, and one of his jobs was to provide payroll data from Morrisons to their auditors, who are KPMG. So he did that task in 2013, but he also went on to make a copy of the data, and this is payroll data relating to thousands of Morrisons employees. He made a copy of the documentation, he published it online, he sent it to 3 newspapers. Newspapers didn't publish it. One of them contacted Morrisons, who in turn contacted the police. Mr. Skelton, although he'd made some efforts to conceal his identity, didn't last very long. He was arrested a few days later, convicted of a number of offences and sentenced to 8 years in prison. Over 9,000 Morrisons employees brought a group action seeking compensation. Next slide, please, Mona. So the claimants brought proceedings directly against Morrisons, saying there'd been breach of Section 4 of the Data Protection Act, misuse of private information, breach of confidence. But they also said that vicarious liability arose under the same 3 heads. Next slide, please. And I'm going to focus on, obviously, the vicarious liability aspect of this. So the trial judge, in relation to the vicarious liability question, held that Morrisons were vicariously liable for Mr. Skelton's breach of statutory duty under the DPA, also his misuse of private information and his breach of his duty of confidence. The judge rejected Morrisons' argument that Mr. Skelton's wrongful conduct was not committed in the course of his employment. Their view was that Morrisons had provided him with the data in order for him to carry out the task assigned to him, and what happened thereafter was a seamless and continuous sequence of events, an unbroken chain. And that phrase, an unbroken chain, as Lady Hale observed, when the case came to the Supreme Court, comes from the judgment of Lord Dawson in the case of Mohammed. And in essence, at first instance, the finding was that the task that Mr. Skelton was asked to do, disclose the information to KPMG, a third party, was very close indeed to the task he actually went on to perform, disclosing it to other third parties. And so the judge considered Lord Phillips' 5 factors from the Christian Brothers case. I found that all 5 were present and found in favour of the claimants. Next slide, please, Mona. Thank you. Case went off to the Court of Appeal, and Morrison's appeal was dismissed. On the question of whether or not Morrisons were vicariously liable for Mr. Skelton's wrongdoing, the court found this. They found the tortious acts of Mr. Skelton, sending the claimant's data to third parties, were in our view, within the field of activities assigned to him by Morrisons. So as the judge at first instance had done, their lordships emphasised the relevant facts constituted a seamless and continuous sequence and an unbroken chain of events. And they also looked at the fact that although Mr. Skelton's motive was to harm his employer, Lord Dawson and Mohammed had said that that motive was irrelevant. So Morrisons are vicariously liable for the actions of their errant employee. Next slide, please, Mona. Thank you. Lady Hale went back to the case of Mohammed. It's got to the Supreme Court to see if the lower courts had understood it correctly, and surprise, surprise, she concluded that they hadn't. Mohammed, if you remember, is the racist petrol station attendant. He took exception to a request by a customer to print some documentation. He swore and was aggressive when the gentleman was inside the kiosk. He followed him back to his car, shouted abuse at him, and then assaulted him, and told him never to return. So Lady Hill said the lower courts had focused on Lord Dawson's final few paragraphs, in where he talked about principles of social justice, which goes back to Hold CJ, and references again to the unbroken sequence of events or seamless episode. And she said, well, that's not the right approach. If it was, then Lord Dawson and Mohammed would have been affecting a major change in the law. She found he was doing no such thing, and it was absolutely clear if you read all of his judgment. So she said when he was talking about an unbroken sequence of events or a seamless episode, he wasn't considering the temporal or causal connection between the various events, but instead towards the capacity in which Mr. Khan, that's the gentleman in the Mohammed case, he's a petrol station attendant, was acting when the events took place. So what Lord Dawson was doing was simply explaining why Mr. Khan was acting throughout in the course of his employment. So each action in that case flowed on from the other. So when he followed the gentleman out onto the corn cause, he was following on from the conversational verbal assault he'd made on him within the kiosk. And when he told the motorist to stay away, he was following up that with reinforcing it with the physical assault. So Lord Dawson was simply finding that throughout, Mr. Khan was purporting to act on his customers' or his employer's business. On the issue of whether or not motive is irrelevant, well, Lady Hale said, well, that's not a question about whether, that's not reference to a question about whether Mr. Khan was acting on his employer's business or for personal reasons. That is really important. That's the key question. Instead, he was commenting on the fact it's not clear why Mr. Khan became so angry and enraged. So she applied that analysis to the case in front of her. So if we can go to the next slide, please, Mona. And she made 4 key findings. Firstly, the disclosure of the data on the internet didn't form part of Mr. Skelton's functional field of activities. It wasn't an act he was authorised to do. Secondly, the fact that the 5 factors listed by Lord Phillips in the Christian Brothers case were all present was nothing to the point, and we've already looked at those factors in the Barclays case. Lady Hale emphasised the factors were concerned not with the question of whether wrongdoing by an employee was sufficiently connected with the employment to impose vicarious liability, i.e. question 2, but instead it was concerned with question 1. Next slide, please, Mona. Next slide, please. Thank you. Thirdly, so although there was a close temporal link and an unbroken chain of causation linking Mr. Skelton getting hold of the data and then his decision to disclose it on the internet and send it off to the newspapers, that of itself doesn't satisfy the close connection test. And fourthly, the reason why he acted wrongfully isn't irrelevant. On the contrary, whether or not he's acting on his employer's business or purely personal reasons was highly material. And so could we go to the next slide, please? So you have to look at, she says, you have to look at things afresh. The question of whether his disclosure of the data was so closely connected with the act he was authorised to do, i.e. sending the material to KPMG, that for the purposes of his liability of his employer to third parties, his wrongful disclosure may fairly and properly be regarded as done by him while acting in the ordinary course of his employment. So obviously, if he hadn't been given any material to send to KPMG, he wouldn't have been able to make a private copy and disseminate it. So his employment had given him the opportunity to commit the wrongdoing, but that's not enough. She makes that absolutely clear. She makes reference to Lord Nicholls' judgment in the Dubai aluminium case, paragraph 32, where it's made clear there's a distinction to be drawn between cases where the employees engaged, however misguidedly, in furthering his employer's business, and cases where the employees engage pursuing his own interest, a frolic of his own, in the language of that time-honoured phrase, as Lord Nicholls puts it. So their lordship found it was abundantly clear in this case, Mr. Skelton wasn't furthering his employer's business, he was pursuing a personal vendetta. And so the circumstances in which he committed the wrongs against the employees were not such as to impose a vicarious liability on his employer. So Morrisons wasn't vicariously liable and the appeal was allowed. Next slide, please, Mona. So where does this leave claimants? Well, first of all, you need to work out the specific acts the employee was authorised to do during the course of their employment. So what does their employment look like? What things are they being asked to do? What's the extent of their role and obligations? And then you look at the Tortious Act. Is it so closely connected with those acts that it might fairly improperly be regarded as being done by them whilst acting in the ordinary course of the employment? So it's important to remember and keep this in mind always when looking at these cases, that simply having the opportunity, Lady Hale's made absolutely clear, simply having the opportunity to commit the wrongful act isn't sufficient to impose vicarious liability. So next slide, please. So two, I hope, quite interesting cases and worth looking at in some detail. I'm sure I've covered a lot of ground that many of you will be very familiar with, but I hope nonetheless it's a useful guide. To conclude then, it's worth looking back at what Lord Phillips in 2012, when he spoke about the law of vicarious liability being on the move. It's 2020, and like most things, it seems to have come to something of an abrupt halt, or maybe it's just a temporary pause, who knows. Anyway, thank you very much for listening.
Thanks very much indeed, Esther, for that. I'd now like to hand over to Holly Tibbitts. He's going to give us an update on Fatal Accident Act claims. So over to you, Holly.
Hello, everybody. Welcome. Thank you, Esther, for that very interesting talk. I'm going to be talking to you about fatal accidents this morning. So without further ado, what I'm going to do is I'm going to start off with an update on the legislation, and then we'll have a look at some of the more recent case law in this area. So, legislation. As you all know, when we're dealing with a fatal accidents claim, we are looking at two key pieces of legislation. The first of which is the Law Reform Miscellaneous Provisions Act 1934. That is the legislation which allows executors of the estate of the deceased to bring claims that the deceased had at the point of their death. That includes, for example, general damages, any loss of earnings, care, and so forth between the injury and the time of death. Funeral expenses paid by the estate can also be claimed under this provision. Now, there have been no changes to this legislation since 1980, so I've got nothing to update you on in that respect. The second key piece of legislation is the Fatal Accidents Act 1976. This allows the dependents of the deceased to bring their own claims for loss of dependency, whether that be services dependency or financial dependency, and it also gives the right for a limited and defined class of relatives to claim for a bereavement award under Section 1A. There are two key changes to the Fatal Accidents Act that you should be aware of, one of which has already happened and the other, for reasons I will explain, has not. The first key change relates to the level of the bereavement award. Those of you working in the field of fatal accidents will know that there have been gradual increases in the bereavement award over time. Following a consultation in the law of damages in 2007, the government said that it intended to increase the award by RPI uprating every 3 years. However, 5 years were allowed to elapse between the update in 2008 and the next increase in April 2013, when the award was fixed at £12,980. For many years since that last update, the legal profession has been vocal about the unfairness that is created by the bereavement award being set so low. It's much cheaper to kill than to maim in this jurisdiction, especially when the victim is a child or a single adult without dependents. It's also particularly galling when you look at what's happening in neighbouring jurisdictions. In Scotland, for example, there's a significantly more generous bereavement award scheme. A much wider class of persons are eligible, including siblings, cohabitees, and claims can be made in respect of unmarried adults. The awards are also assessed on a case-by-case basis and do not uncommonly reach the high 5 figures or more. There are numerous cases reported where awards have been in the region of £80,000 plus. In the Republic of Ireland, there is a capped pot of €35,000 to be shared between the dependents. So again, much more generous than the scheme in this jurisdiction. So has the government listened? Well, the short answer is no. The damages for bereavement variation of some England and Wales order has increased the award to the dizzying height of £15,120. That is only applicable to actions accruing on or after the 1st of May 2020. Presumably that means where the death has occurred after that date, as that is the trigger for the claim under the Fatal Accidents Act. Don't forget that where there are multiple eligible relatives, such as the married parents of a deceased child, the award is still split between them, leaving them with a rather miserly sum of £7,560 each. So the amendment to the award is better than nothing, but it's not really the change that we've been hoping for. Turning to the next legislative update, this relates to the entitlement to the bereavement award. This all arises out of the 2017 case of Smith and Lancashire Teaching Hospitals NHS Foundation Trust. In that case, the claimant's cohabiting partner of 11 years, Mr. Bullock, died as a result of the admitted negligence of the NHS trusts. The claimant, Miss Smith, was entitled to claim for loss of dependency because the Administration of Justice Act 1982 had extended the definition of a dependent to include somebody who had cohabited with the deceased for 2 years or more, a 2-year plus cohabitee. However, the 1982 Act had not made the same change to the definition of those entitled to a bereavement award. Under Section 1A to A of the Fatal Accidents Act, these remained limited to the wife, husband or civil partner of the deceased, the parents of a legitimate unmarried minor, or the mother of an illegitimate unmarried minor. The dependency claim in Smith was compromised as against the defendant NHS Trust, and they then played no further part in the proceedings. But the Secretary of State for Justice was joined as a third defendant so that the bereavement damages issue could be pursued. The claimant's case was that a literal reading of the wording of Section 1A was incompatible with Article 8 of the European Convention on Human Rights, the right to private and family life, and also to Article 14 of the ECHR, prohibition of discrimination, which piggybacks on Article 8. At first instance, the claim was dismissed, and that was on the basis that the judge concluded that the bereavement damages scheme did not fall within Article 8. However, the judge clearly had significant sympathy for Miss Smith's position. He said that if Article 8 had been engaged, he thought that Miss Smith was in an analogous position to a widow, and that treating her differently would have been unjustified and infringed Article 14 of the ECHR. Overall, he agreed with the conclusions of the 1999 Law Commission report, which is over 20 years ago now, that 2-year-plus cohabitees should be entitled to a bereavement award. The claim went to the Court of Appeal, who had the benefit of some subsequent case law from the Supreme Court. They concluded that the judge was incorrect and that the bereavement damages scheme did fall within the ambit of Article 8. Thankfully, on every other point, they agreed with the trial judge. They said that Miss Smith was in an analogous position to a widow, and noted that no justification had been put forward for treating her differently for the purposes of the bereavement award scheme. The court found that Section 1A could not be read in such a way as to make it compatible with the ECHR, and therefore made a declaration of incompatibility. Unfortunately, for technical reasons relating to the ECHR claim, the making of the declaration of incompatibility had the result that Miss Smith was not actually entitled to receive her bereavement damages. But that case has, to an extent, spurred the government on to make a long overdue change to the law. The Fatal Accidents Act 1976 Remedial Order 2019 was laid in May last year, and that proposed the making of 2 key changes, the first of which was to rectify the discrimination against 2-year-plus cohabitees, and the second was to ensure that where there was both a spouse and a qualifying cohabitee, for example in a situation where a couple is separated but not divorced and the deceased partner is now living with a new partner, that the award would be divided equally between that spouse and the new cohabitee. The Joint Select Committee on Human Rights published a report on the order on the 16th of July 2019. It was content with the proposal to include 2-year plus cohabitees within the bereavement award, but did raise a number of other issues about the scheme, including the arbitrary 2-year plus qualifying time, the potential unfairness of equally splitting any award between a partner and a spouse, and also the inappropriate reference to children as legitimate, which is something that I think we've all been uncomfortable with for some time. The committee also recommended that the government look at whether the scope of bereavement damages should be opened up to other family members, including unmarried fathers who are not currently covered by the scheme, parents of adult children, children grieving the loss of a parent, and siblings. The government responded in February 2020, rejecting all of those recommendations, save for the one about illegitimacy. An updated version of the remedial order was laid on the 12th of February this year. As far as I can see, nothing has happened since then, which is perhaps understandable given that the government's focus has been elsewhere for the last few months. The draft wording of that order is on the slide. At this stage, there's no reason to suspect that this change will not be made, and hopefully the government will get on and do this sooner rather than later. It's just a shame that they haven't used the opportunity to broaden the bereavement damages scheme more generally. So watch this space in terms of that change coming into force. So now that we've dealt with the legislation, let's have a look at some recent case law. There are 3 cases I want to highlight to you, the first of which is the 2019 case of AB as personal representative of the estate of GH and KL. The background to this claim was that GH was a motorcyclist killed in a collision with the defendant's vehicle. He left behind 3 sons. The eldest was AB. AB was aged 22 at the time of trial, and as you'll see, he acted as personal representative for his father's estate. He had 2 half-brothers from GH's second marriage who were twins, aged 11 at the time of death and 15 at the date of trial. The case is worth noting because of the approach adopted to elements of the dependency claim that could at best be described as speculative. The 2 most contentious items were the extent to which GH would have given money to each of his sons to help them buy their first home, and secondly, the extent to which he would have contributed to their weddings. The pleaded claim that the claimant had brought was a £15,000 contribution to the first home of each of the three sons, and a £12,500 contribution to weddings on behalf of each son. The defendant's position, unsurprisingly, was that there was so much uncertainty relating to both claims that they should be rejected in their entirety. The court, it was David Edwards QC sitting as a judge of the High Court, was of the view that these claims clearly involved substantial uncertainty, and he actually spent quite a lot of time listing the uncertainties that he was able to identify. For the first home, they included whether the children would have wanted to buy, although he accepted in fact that they would, and AB in fact had bought his own home between the date of death and the date of trial. Whether GH would have wanted to help, how much he would have provided, and whether that would have been by way of a gift or a loan. As for the weddings, there was uncertainty about whether the boys would marry at all, when that might occur, what type of wedding they might have, at what cost, whether GH would have wanted to contribute, how much, and what would the contribution of the future spouse's family have been, and how that would have impacted on GH's contribution. Having considered all of these issues, really more by way of background than anything else, he went on to consider the law and the correct approach to analysing these claims. The court was referred to Kemp and Kemp commentary and to a number of decided cases. The judge in his judgment referred to the 1970 case of Mallet and McGonigal, in which Lord Diplock had said that in assessing damages which depend upon its view as to what will happen in the future, or would have happened in the future if something had not happened in the past, the court must make an estimate as to what are the chances that a particular thing will or would have happened, and reflect those chances, whether they are more or less than even, in the amount of damages that it awards. Reference was also made to the speech of Lord Simon in the 1974 case of Davies and Taylor. In that case, in the context of a question about whether the appellant and the deceased would have resumed cohabitation, thereby allowing a dependency claim, he said, "This is one of those cases where a balance of probabilities is not the correct test. If the appellant showed any substantial, i.e. not merely fanciful, possibility of a resumption of cohabitation, she was entitled to compensation for being deprived of that possibility. The damages would, of course, be scaled down from those payable to a dependent spouse of a stable union, according as the possibility became progressively more remote. But she would still be entitled to some damages down to the point where the possibility was so fanciful and remote as to be de minimis." The judge also referred to last year's Supreme Court decision in Perry and Rayleigh solicitors, in which Lord Briggs had commented on the application of a loss of a chance approach in assessing what would have happened in a counterfactual situation, or where the relevant events are in the future. Having considered these cases, the judge concluded that the correct approach was to consider whether the prospects of the occurrence of the events were fanciful. If the prospects were fanciful, then no damages would be awarded. But, he said, if they are not fanciful, however, damages may be awarded, though in an amount which reflects the likelihood of their occurrence, as the editors of Kemp and Kemp say, in applying a percentage reduction to reflect the hypothetical nature of the claim. It's worth taking a quick minute to look at the evidence that the court considered in assessing the claims. The court had, of course, heard general evidence about GH's financial position, his character, the relationship he had with his sons, and the kind of financial support he had provided prior to his death. In AB's case, this had included lump sum cash payments to support the claimant AB while at university, paying £1,500 for driving lessons, taking him on holiday, the normal Christmas and birthday presents, and so forth. In terms of evidence specifically about house purchase dependency, there was evidence that AB had already bought a home, but the evidence on whether there had been any specific conversations about property purchase was quite woolly and not wholly consistent. Taking into account the broader context, particularly given that GH was in property development before his death, the court concluded that the GH would in fact have wanted to help out when it came to the first purchase of the property. The court also looks at a survey conducted about the bank of mum and dad, which indicated that 27% of buyers receive help from family and friends. So what was the outcome, having considered that evidence? Overall, the judge concluded that the £15,000 claimed for the assistance with the property purchase was too high and settled on a £9,000 figure, not just for AB, but also for each of the twins. There was, in addition to that, a small award for services dependency on the basis that GH, who was keen on DIY, would have helped with the DIY getting AB's new home set up. In terms of the wedding claims, AB's position was different to that of the twins, as he was already living with a girlfriend of about 11 years standing, so a wedding in the near future was a real possibility. The court, to an extent, took into account 3 magazine articles on the cost of weddings, and the claimant submitted that those show that the average cost was about £25,000. Having considered that evidence, the judge considered that the correct award for the contribution to AB's wedding was £7,500, and he noted that that was about 60% of the amount claimed, but interestingly he didn't assess the value and then come to a correct percentage. It seems to have been a after the fact calculation in terms of the percentages. The judge concluded that there was significantly more uncertainty regarding the twins' marriages, given that they were only 15 at trial, but he did not consider that the prospects of a wedding for each of them and GH contributing to those weddings was fanciful, and he therefore made an award of £3,750 each for the twins. Obviously, whether claims like this are likely to succeed will depend on the evidence available and the particular family circumstances. But on the basis of this case, it is well worth including these kind of speculative claims in your schedule. In fact, these claims added up to almost 25% of the total dependency claims in this case, so they made a significant difference to the overall value of the claim. The judgment in AB is also extremely detailed, so a good reference point for anyone looking to refresh their knowledge of dependency claims or looking to quantify losses in a fatal claim. I next want to turn on to a case from earlier this year, Whittam and Steve Hill Limited. This was a claim brought by a wife following the death of her husband from mesothelioma. At the time of his death, the couple were foster parents to 2 children with special needs. The placement had started in July 2015 and had become long-term in 2018. Once the couple had appreciated the extent of the children's needs, it was decided that the husband would stop work to become the main carer for the children, and the claimant would resume her specialist nursing career. As a result of her husband's death, the claimant became the sole carer for the 2 children, who were 9 and 13 at the time of the hearing, and was unable, therefore, to continue with her nursing career. The issue in this case was whether the claimant could recover damages under the Fatal Accidents Act as a dependent on her husband for remaining at home to provide childcare and domestic services to enable her to work. The claim that was advanced by the claimant was based on her own loss of earnings opportunity, or alternatively on a replacement care basis. The defendant said no. This was an attempt to circumvent the scope of the Fatal Accidents Act to effectively recover dependency for the children, who were not eligible dependents under the Act as foster children. Anthony Metzer QC, sitting as Deputy High Court Judge, had no difficulty accepting the claimant's case on the facts. He concluded that if the deceased had not become ill, the claimant would have gone back to full-time nursing and the deceased would have remained at home to look after the children. He would have taken responsibility for most, if not all, aspects of domestic life. Analysing the law in light of these findings, the judge endorsed the position in the 1964 case of Mallion and Plummer, namely that the court had to look at the true situation, irrespective of whether another party involved is not a dependent. Having considered the submissions and authorities, the judge concluded that the dependency claim in this case was that of the claimant and not of the children. Although in non-legal terms the children were effectively dependent, in legal terms they had in fact not lost anything. The care provided by the husband had simply been replaced by the wife following his death. In reality, the claimant had lost her full-time career as a result of her husband's death. She was dependent upon him as a principal carer for the children to allow her to pursue her career in the knowledge that children would be properly looked after. She had a reasonable expectation of a pecuniary advantage as a result of this, namely that the money she would have earned from nursing, and this dependency was therefore recoverable. However, the judge concluded that that did not mean that her loss of earnings was the appropriate measure of dependency. The defendant argued that there was no basis under the Act to compensate the claimant for the claimant's dependency on her own loss of earnings. And the court agreed that the claim for loss of earnings and loss of pension did not fall within the ambit of Section 3(1) of the Fatal Accidents Act. But the court did agree with the claimant's alternative proposition that the appropriate measure was the loss of replacement care. The judge said that the correct approach was to seek the value the services lost as a result of the husband's death, not, as was the approach that had been taken by the care experts in this case, to value the care that the claimant would now be providing. The court made an award on the basis of the full commercial care rate without any discounting to reflect the gratuitous element. It said that these were not services now being provided to an injured person on a gratuitous basis. This was a question of determining the value of the services that would have been provided by the husband if he had not died. And in those circumstances, the commercial care rate was appropriate. So overall, this case is interesting in a number of respects. First, it indicates that you can make a claim for the cost of care that would have been provided to non-dependents by the deceased and is now provided by the surviving dependent at the expense of their career. Secondly, the appropriate measure of loss is replacement care in those circumstances and not the claimant's loss of earnings. And third, when assessing the appropriate rate, the commercial rate and not the gratuitous care rate should be used. Finally, I want to draw your attention quickly to the case of Guilfoyle and North Middlesex University Hospitals NHS Trust from 2018. I'm not going to spend too long on this case as it involves a very niche and slightly tangential point, but I thought it was interesting. Essentially, this case is about the impact of death on provisional damages and variable periodical payments orders. In that case, the claimant had suffered a severe spinal cord injury resulting in tetraplegia. The case was settled for a lump sum and it was agreed that there should be increasing periodical payments and an order for provisional damages. But the parties could not agree on whether any applications for provisional damages or variation of the periodical payments could only be made by the claimant in his lifetime, or whether his estate could also make the said applications. There was some concern on the claimant's side that if his condition deteriorated, he would die before being able to make the applications and therefore would be deprived of damages to which he would have otherwise been entitled. The claimant argued that the estate could make these applications because they were causes of action within the meaning of the Law Reform Miscellaneous Provisions Act 1934. And His Honour Judge Roberts at Central London agreed with that. He said that the LRMPA states that all causes of action survive for the benefit of the injured party's estate, and that the applications for provisional damages or variation of periodical payments both met the criteria of being able to be pursued under that legislation. So he concluded that both the claimant and his estate could make the applications. The judgment is also rather unusually contains the text of the order, which might be of interest to some of you. It was ordered in that case that applications should be made within 12 months of death. So if you're dealing with a claim involving provisional damages or periodical payments, think about the relevant period for applications extending beyond death. And if you happen to be in the unusual position of dealing with a claim where there has been entitlement to provisional damages and or a variation of a PPO has arisen, but the claimant has died before making the relevant applications, you know that there is potentially scope for the estate to still pursue these damages. That's all from me. Thank you very much for listening. I hope that's been of interest. My email address is on the screen. Please feel free to get in touch if you want to discuss anything arising from this or more generally. I will now hand back over to Adam.
Thanks very much indeed, Holly, and thank you again to Esther. Just before we go, want to say a big thank you as well to our marketing director, Mona, for arranging the seminar and making sure everything ran so smoothly. We very much look forward to welcoming you to our Norwich Street premises as soon as we can. But in the meantime, the 5th in our series of 9 Goff Chambers webinars will take place at 3 o'clock next Wednesday, the 17th of June. We'll be sending out further details about that later on this week. Stay safe, stay well, and very much look forward to seeing you all soon.
Thank you.
Thank you.